So let's talk about the structure of the court system. We have this dual court system in the United States. So we have federal court system, and then each state and each territory has a completely separate, completely different system of their own. Each state has a structure. Usually there is a lower court system, an appellate court system, and then a Supreme Court or court of last resort system. In some states, the governor appoints the judges. In many more states, the judges are elected, especially southern states across the Sun Belt. Their judges are elected. So, like in the state of Texas, every judge except for city court judges is elected. Justices of the peace, district court, county courts, the Supreme Court. We have a court of criminal appeals. We have appellate courts. All of them are elected. Now, there are some states that kind of have this hybrid system. It's called the Missouri Plan. So in the Missouri Plan, the governor initially appoints people, and then they have to run to keep their jobs. So the governor gets some input, and if they're doing a bad job, the people in the state can vote them out. The state court systems hear a lot more cases than the federal court system. More than 95% of the nation's legal cases are decided by state courts or local courts. This is from an old book, but this is literally my favorite graphic to visually represent that there is a state court system, trial courts, court of appeals, Supreme Court, and a separate federal system. Notice that from the state Supreme Courts, cases can go to the Supreme Court of the United States. But that is only if they are asking a question that has to do with what the Supreme Court can hear. Let's have a conversation about jurisdiction. So, and let's do that by looking at Article 2. So the word jurisdiction, law say, what does the law say? I'm trying to speak Latin. Basically says that there are certain cases that a court can hear. What authority does this court have to hear a case? So I'll give you an example. Say I'm Madelyn Bowman from Texas, go to Louisiana, and I rent a car, and I don't get the insurance from the rental car company because I think I have insurance. My insurance is actually lapsed. So I'm driving uninsured in Louisiana as a citizen from Texas. And so I drive out of the car lot, and I'm driving down the little 2-lane road that comes out of the airport, and I get hit from behind by a person that is born and raised in Louisiana. And unfortunately, this person doesn't have any insurance either. And the only significance of neither of us having insurance is that I'm going to have to file the case myself. No insurance companies are going to be involved. It's just me and him. So where can I file this case? Can I file the case in Hawaii? It is easy to hear when I say that, that's crazy. No, I'm not from Hawaii. uh he's not from Hawaii. Nothing happened in Hawaii. That simply means that Hawaii doesn't have jurisdiction. They don't have any authority to hear cases from something that happened in Louisiana. What cases do have the authority to hear this case? Well, obviously, Louisiana State Court is going to have the authority to hear this case. Yes? Maybe the Texas state courts have the authority to hear the case. I'm from Texas. I'm certainly going to want to run up to the Texas courthouse and file suit and have everything be nice and neat near me. Might even see somebody I know. Now there's a possibility that the case could be heard by a federal court. Here in Section 2 of Article 3, it lays out the times when when the Supreme Court has jurisdiction. So they can hear all cases that arise out of the Constitution, the laws of the United States, and treaties from the United States. They can also hear all cases affecting ambassadors, public ministers, and consuls. So if it has to do with a person that is from another country, I don't care if it's a traffic ticket, it goes straight to the Supreme Court. They can hear those cases. They can also hear cases of admiralty and maritime jurisdiction. So if it has to do with something that happened out on the ocean or waters, then that can go to the Supreme Court. They can hear controversies where the United States is a party. They can hear controversies between two or more states. They can hear controversies between a state and a citizen of another state. They can hear controversies between citizens of different states. So there in my example, I'm from Texas and he's from Louisiana. There might be an ability for the case to be heard. Now, the way that law has progressed, I believe that the amount in controversy has to be more, the amount that you're suing for has to be more than $50,000. Goes on to say between citizens of the same states claiming lands under grants of different states, and between a state or citizens and foreign states. So those are the kind of cases that federal court can hear. Now, next paragraph. If it involves an ambassador, public ministers, or consuls, then the Supreme Court has original jurisdiction, meaning you can only take that case straight to the Supreme Court. They hear it first, original first. All other cases mentioned, they can go to lower courts, and the Supreme Court will can hear the appeal, unless Congress passes a law that says that it goes straight to the Supreme Court. Marbury versus Madison aside. So that is Article 3. There are 3 sections to Article 3. One of them is saying there's going to be a Supreme Court, Congress can set jurisdiction below, and that the members of the Supreme Court will receive compensation, which is right now about $230,000. They make a little bit more than the members of Congress. And the Chief Justice makes about $15,000 more than everybody else. Section 2 is establishing what kind of cases can be heard in federal court, including the times when the Supreme Court has original jurisdiction, and that's if it involves ambassadors or if the state is a party. And then it talks about treason. We've heard that word bandied about quite a bit recently, but treason only comes into effect if we're talking about war times. And it involves actually giving information or aid to enemies. And it talks about what circumstances under what circumstances it is allowable for someone to be convicted of treason. That is all of Article 3. So here's a summary of what we just looked at in Article 3. Constitution of the United States, establish a judiciary, that it is a separate and independent branch. They establish a Supreme Court, and then said, Congress, you decide what the lower courts are going to look like if you so desire. The federal judges are nominated by the president. They are given compensation. There is no age requirement. There's no residency requirement. There are no citizenship requirements in the Constitution. And the only way that a judge, once they have been confirmed, leaves office is if they pass away, they resign, or they are impeached, the same way a president would be impeached. They hold their office during good behavior. So judges have their jobs for life. And that was meant to remove political pressure so that they won't be making decisions based on being reelected or what the president is going to do to them, because the president can't do anything to them. They have their job. Presidents can't even impeach them. And you can't be impeached because you made a bad decision or a decision that people don't like. The only reason that you could be impeached is if you had some type of misconduct. So it is very difficult and very unusual for people to be impeached and actually removed from office. For the most part, you got this job until you don't want it anymore or pass away. So we alluded to the concept of original jurisdiction, and that simply means the case where you go file the case. Courts that have original jurisdiction can conduct trials. They gather evidence, they gather facts, they look at the applicable law, apply the law to the facts, and decide if somebody is going to is going to be fined or go to jail or put to death, fined, all of that is criminal, or whether or not they lose the case, disputes. And we also saw in Article 3 that there are 2 situations where the Supreme Court hears a case first. They go directly to the Supreme Court. That is, if it has to do with foreign diplomats, ambassadors, consuls, and ministers, or if a state is a party. And that is it. So it said in all other cases, the Supreme Court shall have appellate jurisdiction. Appellate jurisdiction means that you have the opportunity to review cases. Now, this is the big thing to remember about appeals. They cannot review facts. They cannot go back and say, how did you ever interpret that way? The only thing that can be reviewed is decisions by the judge, legal decisions. Is this, did the judge decide something wrong? Did the judge exclude something? Did the judge um, um, interpret this part of the law wrong? But it is always and only legal. So if it arises out of the United States Constitution, out of federal law, out of regulations and treaties, then the Supreme Court has the jurisdiction to hear that type of case. If we recall, like Mapp versus Ohio, Miranda versus Arizona, Gideon versus Wainwright, those were all state court cases. But they all involved some part of the Constitution. And when they were talking about the constitutionality of the state law, then that brought it into the jurisdiction of the Supreme Court. So then the Supreme Court can pull a state court case up and say, yeah, this is fundamental, and we are going to say that now every police officer has to read Miranda rights to anyone they're interrogating. So appeals that cross state or national boundaries, that involve federal law and interpretation of federal law, or involve the Constitution, can go to the Supreme Court. Let's talk a little bit more about structure. So we're now talking about the federal court system. There are 94 federal district courts. In Texas, I know that there are at least 7. There's one in Fort Worth. There's a federal court in Fort Worth. There's one in Dallas. There are 2 in Houston. There's one in Sherman. Oh, and there's those are the ones that I know off the top of my head. Some states only have 1 district court. Texas, of course, is going to have several. Then we have that middle layer, the appellate court system. And there are 13 courts of appeals. Let me show you a picture. So here's Texas, and you see Texas, Louisiana, and Mississippi. And you see this 5. We are in the 5th district. Now, we actually call these courts of appeals circuit courts. So you may hear that a case was appealed to the 5th Circuit. Texas is in the 5th Circuit. President Trump complains all the time about the 9th Circuit. That's California, Nevada, Oregon, Montana. Arizona's in the 9th Circuit. And the reason they call them circuit courts is really quite simple. Before they established a location, like the 5th Circuit Court is in New Orleans, but those judges used to go to the various states within their jurisdiction, and they had like a set schedule, so they had a circuit, and so we still call them circuit courts even though they don't travel anymore. So there's 11 of these. And then there are 2 more courts. One of them has jurisdiction over the District of Columbia, so Washington, D.C., and one of them hears appeals on patents and international trade. So a total of 13, 11 circuit courts. And then at the top, there is one Supreme Court. So this is the graphic from the book. This again outlines that there's a state court system, there's a federal court system, 94 district courts, 13 courts of appeal, one Supreme Court. Cases can come from state Supreme Courts to the Supreme Court. They can come from the Court of Appeals to the Supreme Court, and they can come from federal claims courts, specialty courts to the Supreme Court. The process is this. To become a judge, you have to be nominated by the president at the time. And that is for every court. District Court in Fort Worth, that person was appointed by a president. The district courts usually have one judge. The appellate courts will have from 3 to 7. There may be even a couple that have 9. And they usually hear the cases in 3-judge panels, and you just never know which ones you're going to get. Some of those people have been there since the 70s. I think there is a judge, an appellate court judge in the Ninth Circuit that was appointed by Jimmy Carter. Jimmy Carter was president in 1970, from 1972 to 1976. So, that is the process. If it is a lower court, a lot of times the president will say, hey, get me somebody, and they just have this list. And so when a position becomes open, they nominate the person. They send the names over to the Senate. Kind of depends on if the Senate is the same party as the president. If the Senate is a majority of the opposite party, then you see all kinds of legal and political maneuvering. If they're the same party, for the most part, they say, okay. Now, up until a few years ago, there was a requirement that you had to have 60 judges approve any court nominee. And that way you wouldn't be able to just railroad and have the majority party pick all partisans. And then when there was a Democratic majority in 2008 and Barack Obama was the president, he was getting a lot of resistance from the minority party, from the Republican Party. And so they wouldn't supply anybody to vote to make the 60. And they were filibustering to keep the nominees from actually making it to the, actually getting a vote. So the majority leader at the time was a Democrat named Harry Reid. Harry Reid just decided that they were going to change the Senate rules to just having to have a majority for lower court judges. So at that point, President Obama was able to appoint several people because they did that legal maneuvering. They just changed the Senate rules. Now but that did not include Supreme Court justices. Then in 2010, the Republican Party took over as the majority party. They kept the rule that you only have to have approval for lower court judges by a majority and not 60. And then added that and then expanded it and said you only have to have a majority for Supreme Court justices too. So I'm senatorial courtesy has kind of gone the way of the dinosaur, but it is this concept that if a senator doesn't like someone that is going to be appointed in their state, they can say, "Yeah, I don't know," and so for lower court judges that the president doesn't really know anything about, um, a lot of times that works. That's fine. Then I won't appoint that person to the district court. But if the person is from a person's state and they are being nominated for Supreme Court, they don't pay attention to senatorial courtesy that I know of anymore. So the nominations basically allow the president to influence judicial policy because of some of the things that we talked about for years. And I am going to talk a little bit about the makeup of the court. So, right now, we have 6 men and 3 women. Within the federal judiciary in general, white males are overrepresented, just like they are in Congress. Women and minority group members have been making substantial gains, especially Jimmy Carter appointed quite a few Democrats. So did Bill Clinton, and he appointed quite a few women and minorities. And President Obama, goodness, he appointed the first Asian members. There were a lot of Hispanic members. He nominated Justice Sonia Sotomayor, who is the first Latina Supreme Court justice. So about 2/3 of Obama's appointees were either women or minorities or both. And so the Supreme Court has become more demographically representative. And for the most part, they just don't nominate people that have not served on the appellate court level. Most of the people that are on the court either went to Harvard or Yale Law School. They are all Jewish or Catholic. Almost all Jewish or Catholic. And so there is diversity of, we have one African American member, that's Clarence Thomas, and one Elena Kagan, who was appointed by Barack Obama or President Obama, is the only one that is on the Supreme Court that never served as an appellate court judge, but she was the Solicitor General, which is the attorney that represents the United States at the Supreme Court for years. So I think that was probably okay. Let's talk about the confirmation process. President Reagan nominated a guy named Robert Bork. I am just going to let you hear a little bit of Robert Bork's voice.
This was Judge Robert Bork's second day of confirmation hearings before the Senate Judiciary Committee, and it was a day marked by more sharp questions about Bork's interpretation of the Constitution, on the right to privacy, on equal protection for women, and on the right of free speech. The day began with an exchange with a Democratic opponent, Senator Howard Metzenbaum. He asked about Bork's role in the so-called Saturday Night Massacre, the events in October 1973, when then Attorney General Elliott when then Attorney General Elliot Richardson and his deputy William Ruckelshaus both refused a Nixon White House order to fire Watergate Special Prosecutor Archibald Cox, who had gone to court to get access to secret White House tape recordings. The job was left to the Justice Department's number 3 man, Robert Bork. Bork today explained why he acted as he did, and insisted that his actions did not in any way slow down the Watergate investigation.
Was there ever any doubt in your mind that the people in this
Was there ever any doubt in your mind
expected the special prosecutor to go forward and obtain the facts with respect to the matter of Watergate?
There was never any doubt
in your mind.
No, there was never any doubt in my mind.
in your mind
People in the country wanted that prosecution investigations to go forward and prosecutions to result is justified. And there was never any doubt in my mind that I wanted justified. And in fact,
never any doubt in my mind that that's exactly what I
was
wanted.
intact and
And
going
in
forward.
fact, I did my utmost to keep that special prosecution
Both
force
men
intact
assured
and
the
going
staff
forward.
that its work would continue with the cooperation of the Justice
Both
Department
men
and
assured the
without
staff
interference
that
from
its
the
work
White
would
House.
continue with the
And
that's
cooperation
exactly
of the
what
Justice
happened.
Department and without
Even though they had
interference
some
from the White House.
Did
And that's exactly what happened.
You went forward and
even
did
though they had
this
had some
act
experience
which the
in this
court
area,
declared
that
determined to be
because of
an
that,
illegal act.
you
Isn't
went
that pretty
forward
hard for the
and
American
did
people to
this
accept?
act, which the court declared
If I thought it was just a
determined to
question
be
of
an
replacing
illegal
one
act.
lawyer with
Isn't that
another,
pretty
it
hard for
would
the
be pretty
American
hard to
people to
accept. That's
accept?
not what was taking place, however. If I thought it was just a question of replacing one lawyer with another, it would be pretty hard to accept. That's not what was taking place, however.
Elliot and Bill were both quite strong on the point that if you do it, don't leave, because the department
Elliot and Bill
needs
were
this
both quite
continuity.
strong on the
And I
point
was the one person
that if you do
was
it,
the
don't
depart-
leave because the department needs this continuity. And I was the one person who was a department. Eloquent.
Okay, we'll stop it there. So, Mr. Bork went on to discuss the fact that, and he had written many articles where that he did not believe that the right to privacy was constitutional. And remember, that is the basis of Griswold and Roe versus Wade, and Lawrence hadn't been heard at this time. But Griswold and Roe versus Wade had been. He also criticized the laws and the way that the court had interpreted equal protection laws. He did not like the Voting Rights Act. He did not like the Civil Rights Act. He thought that the 14th Amendment only applied to former slaves. He had written about this, and if you ask him, you hear his voice, he was telling you exactly how he felt and how he would vote. Interest groups showed up. They started protesting. They started calling their senators, and they said, please do not confirm this man. And they ended up denying his confirmation. We didn't have a Robert Bork as a Supreme Court justice on the court. Now, what happened to him, we sometimes call getting borked, where you tell your opinion and people don't like it, and the justices are too embarrassed to confirm you. So what does that lead us to? Now, if you watch a Supreme Court hearing, a Supreme Court confirmation hearing, those justices won't answer anything. If you watch Amy Coney Barrett's, if you watch Brett Kavanaugh, they will not answer questions. How do you feel about Roe versus Wade? Well, Roe versus Wade was a case that was heard by the Supreme Court in 1972. Well, how would you decide on that case? I don't think that it is appropriate for me to talk about how I feel about this issue or how I would decide a case. They will not answer questions. So this was in 1981 or 2. Since then, you cannot get strong opinions from any Supreme Court justice. It's just no, not happening. So in 1993, 1992, 1993, the guy that had worked for the NAACP and that had argued the Brown versus Board of Education case uh, for the Supreme Court in front of Earl Warren was a guy named Thurgood Marshall. Thurgood Marshall was a civil rights advocate. He was the first African American man, or first African American period, on the Supreme Court. Of course, he was very, very, very liberal. And he passed away when George H.W. Bush was president. So there was a lot of pressure to replace one black justice with another black justice. And George H.W. Bush was like, that's cool, I can do that. So he goes and he nominates Clarence Thomas. Clarence Thomas was a Republican, was very conservative. He was the polar and exact opposite of Thurgood Marshall. So as they were going along, they're asking him questions, and they've already established he's not going to answer questions. He's not going to answer questions about how he would decide cases. And then a young lady came forward. Her name was Anita Hill. And Anita Hill actually accused him of sexually harassing her. We'll hear a little bit of her voice.
During this period at the Department of Education, my working relationship with Judge Thomas was positive.
During this period at the Department of Education, my working relationship with Judge Thomas was positive.
I thought he respected my work.
I had a good deal of responsibility and independence. I thought he respected my work and that he trusted my judgment. After approximately 3 months of working there, he asked me to go out socially with him. What happened next and telling the world about it are the two most difficult experiences of my life. It is only after a great deal of agonizing consideration and great number of sleepless nights that I am able to talk of these unpleasant matters to anyone but my close friends.
And explain to him that I thought it would jeopardize.
I declined the invitation to go out socially with him and explained to him that I thought it would jeopardize at the time I considered to be a very good working relationship. I had a normal social life with other men outside of the office. I believe then, as now, that having a social relationship with a person who was supervising my work would be ill-advised.
I thought that by saying no and explaining my reasons, my employer would abandon his social suggestions.
I thought that by saying no and explaining my reasons, my employer would abandon his social suggestions. However, to my regret, in the following few weeks, he continued to ask me out on several occasions. He pressed me to justify my reasons for saying no to him. These incidents took place in his office or mine. They were in the form of private conversations which would not have been overheard by anyone else.
So basically, she was accusing him of sexual harassment.
Became even more strained.
And so after they took the testimony, and she explained that it was bad. She talks about him talking about pornographic movies. She named the movies. She just was describing a very uncomfortable relationship. Now, this is how Clarence Thomas responded.
Did not occur.
When it came time for him to publicly respond to the allegations, Thomas turned the tables on his interrogators, and for all intents and purposes ended the debate.
Thomas turned the tables on his interrogators, and for all intents and purposes ended the debate.
This is a circus. It's a national disgrace. It is a high-tech lynching for uppity blacks
That unless you
who in any
kowtow
way
to
deign
an
to
old
think
order,
for themselves.
you will be lynched,
And it is a message
destroyed,
that unless you
caricatured
kowtow to an old order, you will be lynched,
by a
destroyed,
committee of the
caricatured,
U.S. Senate rather than hung from a tree.
by a committee of the U.S. Senate.
So, bottom line, Clarence Thomas accused the members of the Senate of being racist and lynching him, and everybody backed off. And there you see, this is the earlier this year. There's Clarence Thomas. He ended up being confirmed by the Supreme Court. So the attempts to address character, since we couldn't talk about issues, failed. So here on this court, we have Sonia Sotomayor, Elena Kagan, there's Brett Kavanaugh, Neil Gorsuch, this is Stephen Breyer, appointed by Bill Clinton. There's Clarence Thomas. This is Ruth Bader Ginsburg, who passed away about a month ago, 6 weeks ago. She was the oldest member of the court, and she had several bouts with cancer. And this is Samuel Alito. Samuel Alito was appointed by George W. Bush, and so was Chief Justice Roberts. Now, the Chief Justice always sits in the center. That's how you can tell. The newest member of the court to replace Ruth Bader Ginsburg is Amy Coney Barrett, and this is her being sworn in quite symbolically by Justice Clarence Thomas. And here's President Trump, who nominated her, and her husband. So she has not heard a case yet, but she was recently sworn in and will be the 9th member of the court. That just shows you the people that we're talking about and who appointed them. Sonia Sotomayor and Elena Kagan were appointed by President Obama. Justice Roberts and Samuel Alito were appointed by George W. Bush. Ruth Bader Ginsburg and Stephen Breyer were appointed by Clinton. Clarence Thomas was appointed by George H.W. Bush. He only had one term. And Anthony Kennedy, who retired, and so he was replaced by Neil Gorsuch, and so appointed by President Trump. This is an old picture. Y'all know I'm crazy about Earl Warren. So this is the Warren court. There's the Chief Justice sitting in the middle. Earl Warren was actually a tall guy. So this was a court that was so judicially active between 1954 and 1969 and passed a lot of, or heard and decided a lot of the cases that changed criminal jurisprudence and changed some of the civil laws. How do courts decide which cases they're going to take? Well, number one, the party that lost at the lower court has to appeal it. And they do something that is called the Rule of Four. The Rule of Four says this. They will present the case to the justices, and the justices will basically vote. Yes, I want to take it. No, I don't. If 4 justices say I want to take the case, then they will grant what is called a writ of certiorari. I don't have any of this in italics. There we go with some more Latin. A writ of cert is issued, and they say, send the case up, send us your records, send us your briefs. We're going to hear your case. So, Rule of Four. They don't usually accept routine cases. They usually don't accept cases where all they're going to do is confirm what was heard before. They get thousands of appeals. They usually hear less than 100. Usually it's somewhere around 80 in a year. They don't have to accept any case. They have to have some compelling reason to accept the case, either because there have been different rulings in different appellate courts, or there have been different rulings in different Supreme Courts, state Supreme Courts. And so usually if they are accepting a case, 3/4 of them, they are reversing a lower court's decision. If they accept the case, it is very rarely to say y'all were completely right. So 8,000 cases a year, they hear about 87, 88. When the case makes it to the Supreme Court, the attorneys that are going to argue the case are given 30 minutes per side. And so they get started talking, and then the justices pepper them with questions. I think I had you guys listen to a Supreme Court hearing, and I'll have you listen to another one, because this is what we're simulating in our arguments at the end. Although the judges won't be able to ask you questions while you're talking, the judges can submit questions that you need to answer. So you will explain what federal law, what part of the federal Constitution is addressed, and then you will explain your arguments based on your case. The justices attend the judicial conference after they hear, and then they vote. And if it's real clear, then they say, well, we'll go ahead and issue this decision. If there's some argument, then those cases, they start in October, they end in June. And those cases, the cases that they've been arguing over or that people have been going back and forth about, come out in June. The proceedings are secret. They won't allow cameras into the court. You have to have special clearance as a member of the press to actually even sit in the Supreme Court, but they do tape their proceedings. So then once they decide, they vote and they decide who won, then they issue what is called an opinion. So the people that won, that's called the majority opinion, got the most votes. Sometimes opinions, everybody doesn't agree with the reasoning, so they agree with the decision, but they disagree on some legal basis. And so they'll say, yes, this party won, but because of this. So the majority opinion says these people won. You can also have a concurring opinion. I agree with the decision, but I think it should have been because of this. And then the people that did not win, that were in the minority, issue what is called a dissenting opinion. And so they explain why they think that the majority was wrong, how they would have decided the case, how they think that this is going to affect people in the future. And a lot of times it seems kind of futile to have the people that didn't win write their opinions. But over the years, when cases get overturned, a lot of times justices will go back and look at dissenting opinions. They certainly did that for, in Brown, they looked at the dissenting opinion in Plessy. So you do this for the future in case times and opinions and justices change. You explain why you don't like your opinion. So we talked about the American court system. We talked about the concept of judicial review. This is what puts the federal courts in such a high and strong position, and that was because of the Marbury versus Madison case. We talked about stare decisis. There, I finally got it italicized. That English common law concept that we are going to follow court decisions and will only in most extreme circumstances overturn them, and we have to explain why we are overturning it. There has to be some extremely compelling reason to overturn a previous case. Decisions that the court makes can have both legal and political impact. So sometimes they completely change politics. Never heard of pro-life, pro-choice before Roe versus Wade. So there are times when we'd never heard of Miranda rights. Now we say it like we say he hadn't been read his rights. Well, there was no precedent before then. But there are times when the decisions that the courts make have such a huge impact that they become a part of our everyday lives. So the Supreme Court, is quite powerful. The federal court system is quite powerful. So the next quiz will be over chapter 12 and 14. 10 questions from chapter 12, 10 questions from chapter 14. But they will both come out of a pool. So I hope that I have made it clear. I really like how many district court cases, what is judicial restraint, Marbury versus Madison case questions. Those are most popular with me.